Hello. Good to see you. I'm Dean Horace Anderson of the Elisabeth Haub School of Law at Pace University, and I'm very pleased to welcome you today to the presentation of the 2023 Elisabeth Haub Award for Environmental Law and Diplomacy. Today's ceremony is taking place at Pace University in New York City, and we are joined by environmental law advocates and supporters, both in person and around the world. Brazil, Peru, South Africa, Tonga, Switzerland, Germany, France. These are some of the locales from which we are gathering today. And we've all come together to honor and celebrate the global impact and achievements of two bold diplomats, Ambassador Marja Lehto and former Ambassador Marja Jacobsson. Ambassador Lehto is senior expert on public international law for the Ministry of Foreign Affairs of Finland, and until recently, Ambassador Jacobsson served as principal legal advisor on international law for the Ministry of Foreign Affairs of Sweden. While they were members of the United Nations International Law Commission, both served successively as special rapporteur for the topic of the protection of the environment in relation to armed conflict. In this role, they worked tirelessly for a decade to develop the draft principles of international law to protect the environment in times of armed conflict, and then skillfully led the adoption of the draft principles by the International Law Commission and their acceptance by the UN General Assembly in 2022. The principles lay out the urgent need and common objectives, reinforcing and advancing the conservation, restoration, and sustainable use of the environment for present and future generations, specifically with respect to the protection of the environment in times of armed conflict. This was no easy task, requiring leadership, tenacity, and boundless perseverance. And I can think of no better time than the present to honor the work of Ambassadors Lehto and Jacobsson, especially given recent conflict in Ukraine and the Middle East, and the devastating impact not only on innocent civilians, but on the environment and the planet we all share. This year marks the 26th anniversary of the Elisabeth Haub Award for the Environmental Law and Diplomacy, the world's most prestigious award in the field of environmental law. The award was established in 1997 by Haub Law in cooperation with the Haub family to honor the legacy of Elisabeth Haub, a noted philanthropist and advocate for strong laws for the conservation of nature. It was first established to commemorate the 25th anniversary of the United Nations Stockholm Conference and the 5th anniversary of the United Nations Rio de Janeiro Earth Summit. Chosen annually by an esteemed jury of global leaders in environmental law and diplomacy, the Haub Award recognizes the innovation, skill, and accomplishments of lawyers, diplomats, international civil servants, and other advocates who work to support the world environmental order. We are pleased to have with us today members of the Haub family, Pace University trustee Lilian Haub, Christian Haub, and their daughter, Marie Lilian. With their support, our preeminent environmental law program continues to train lawyers that understand the intersection between justice, the environment, and the law. We are also joined by several members of our faculty and several members of the distinguished Haub Award jury. We thank you for volunteering your time to recognize exceptional accomplishments in this field. It is now my pleasure to introduce to you Pace University's president, Marvin Krislov, a lawyer by training who is deeply committed to the work of Haub Law's environmental law program. I will now turn the podium over to President Krislov. Marvin.
Thank you, Dean Anderson, Ambassador Lehto, and Ambassador Jacobsson. Thank you for being here, and congratulations on your honor. Trustee Lilian Haub, Christian Haub, Marie Lilian, and I gather Anna Sophia will be here shortly. So thank you all for being here, and thank you for your leadership. And on behalf of all of us at Pace University and the Elisabeth Haub School of Law, I want to thank everyone both here and on the Zoom for joining us as we honor these extraordinary leaders. The Haub Law School is known for many things. We train committed and engaged attorneys. Our path to practice curriculum ensures that our graduates are prepared to be effective advocates as soon as they start their careers. Our clinics allow our law students to contribute to their community even while they're still in school. But more than anything else, the Elisabeth Haub School of Law is known for its commitment to and excellence in the crucially important field of environmental law. And it is our great privilege to be stewards of the Haub Medal, the most distinguished award for environmental law and diplomacy in the world. Our partnership with the Haub family and the family's deep commitment to the environment has been critical to the development both of this school and to the field of environmental law. For decades, our faculty have been pioneers in developing this field, and they continue to serve as world leaders. Our alumni work in environmental agencies, nonprofit organizations, corporations, law firms, and law schools and universities throughout the country and around the world. This is especially true of Professor Nicholas Robinson, who has played such a crucial role in the field and at our law school, and who will lead our program this afternoon. Thank you, Nick, for everything you've done. Nick and our many law alums, students, faculty are all following the model of Elisabeth Haub, who was so devoted to the progress of environmental law. She was a woman before her time. She was a woman focused on environmental law well before it became popular. Long before most of us, she recognized the impact that human development had had on the world's environment, and she advocated for policies that would preserve and protect our planet and natural resources. We are so pleased to have this law school and this medal named in her honor. We are also pleased to be able to carry on her legacy by recognizing the work of people like Ambassador Lehto and Ambassador Jacobsson. Given the war in Ukraine and now this situation in Israel and the Middle East, this work is not only important, but extraordinarily timely. Professor Robinson is here to introduce the laureates, and I'll now turn it over to him to discuss in detail the contributions of our honorees. Nick?
Well, a warm welcome to all of us here in person and those who are attending virtually around the world through the internet. We meet this afternoon to commemorate a singular accomplishment and honor two individual jurists without whom this achievement could not have been. It is a unique moment because the event we celebrate fills a gap both in humanitarian law and environmental law. The protection of the environment before, during, and after armed conflicts is our topic and our theme. It also passes a grave obligation onto each one of us attending here today to carry forward the work of these principles. Since the 1972 Stockholm Conference on the Human Environment, all nations have enacted laws to protect the environment and have agreed on principles and treaties to protect aspects of the marine environment, the atmosphere, migratory species, hazardous substances, and other themes. States took seriously the urgency of doing so when they agreed by consensus in the great document Agenda 21, an historic 800-page soft law agreement adopted by consensus at the 1992 Rio Earth Summit, the UN Conference on Environment and Development. That conference also adopted a declaration that had 27 principles in it. In 1991, there's a backstory to some of these principles. In 1991, in New York, the International Council of Environmental Law held a workshop in support of an official drafting group, which Ambassador Tommy Coe, who was the chair of the preparatory committee for UNCED and then chaired UNCED, had assembled here in New York to come up with a first draft, would you call it a zero draft these days, of that declaration that could be adopted at the Earth Summit. The ISIL shared with the workshop some basic principles of environmental law, such as the obligation to have public participation in environmental decision-making, the role of environmental impact assessment, and so on. And Sweden's delegate at that workshop affirmed ISIL's recommendations to include principles related to the United Nations mandate to cooperate to keep the peace. Eventually, that provision became draft Principle 24, which provides that, I quote, the warfare is inherently destructive of sustainable development. States shall, therefore, respect international law providing protection for the environment in times of armed conflict and cooperate in its further development as necessary. And said adopted this draft declaration without further debate, and it became the text that the General Assembly accepted. It has been widely endorsed ever since. The story of how the Rio Declaration has had an extraordinary success in shaping international environmental law belongs to another event. Today, we focus specifically on how the UN International Law Commission took on the task for states under this provision of Rio Principle 24 to progressively develop and codify their obligations to protect the environment in times of armed conflict. Jurists, for example, the late Professor Alexander Kiss, have argued that environmental law may not be suspended during armed conflict. But what exactly are the duties that states shall honor and how? The Rio Principle was silent on that. For much of the past decade, the UN International Law Commission has wrestled with this sort of question. This past year, the ILC completed its deliberations, sending to the General Assembly its draft principles on the protection of the environment in relation to armed conflicts, plural. The ILC is provided for, as those of you who study international law know, are among our students, in the United Nations Charter. We are honored to have here today the chairperson of the International Law Commission, Dr. Nilofer Oral, a professor, and the first expert, I would say, on environmental law to chair the commission. So we're doubly pleased. The General Assembly elects the members of the International Law Commission based on their expertise. It's an arduous task to become a member of the commission, stand for election in the General Assembly. And then the ILC selects from among its members a rapporteur who is tasked with researching and providing drafts of legal analysis on international law topics that the ILC has elected to study. It must be acknowledged that the United Nations member states do not fund this work adequately, and each rapporteur must be creative in inviting support for the necessary research that's to be adopted. Each rapporteur must personally invest huge amounts of her time, her own time, in these tasks. The studies of the rapporteur are closely then critiqued across the distinguished jurists who come from different legal traditions, the civil law, the common law, socialist law, and also from national legal systems, east-west and north-south. The two laureates who we celebrate today, as with other rapporteurs, have had to run the gauntlet of these critiques and deep inquisitions as to what should be the agreement of the Commission to recommend to the states. The importance of the new International Law Commission's principles we honor today cannot be underestimated. Preparing this text for acceptance was skillfully led throughout the process by each of the two special rapporteurs. First, Professor Maria Jacobsson, and second, Ambassador and Professor Marja Lehto. After honoring our two laureates, you will participate and be invited to participate in a panel discussion on the significance about what these principles mean for us today. But let it be said briefly at the outset that these principles are indeed a milestone in humanity's efforts to safeguard Earth's biosphere. They are a realistic testament of hope and pragmatic sanity. At a time when armed conflict in places such as Myanmar or Burma, such as Sahel, Ukraine, and now Gaza are seen to be violating the most basic norms of humanitarian law, a skeptic may ask, why celebrate adding some new rules to protect the environment? Well, as Marvin Krisloff has indicated, Elisabeth Haub knew the answer. She knew the answer to that question at a time when the forest dieback in Bavaria was extreme, when pollution in Europe was acute and monuments were being melted by the acid rain. She knew this could not be sustained, In the 1960s, she advocated for the creation of laws to protect the natural environment. There was a time when virtually no laws prevented the destruction of nature, and many laws allowed it expressly. She answered the skeptics of her day with a clear vision, holding that the law must protect nature, or the day would come when humans would no longer be at home in nature. The pioneers who enact the initial laws to halt environmental degradation set the ground rules for the future. Today, we honor the ILC through our two cherished laureates who have done this pioneering work. Through conferring the Elisabeth Haub Award, Pace University and the family Haub are honored to recognize and honor these rare individuals who are the forerunners for needed environmental reform and who make it possible for the next generation to campaign to implement and refine the norms that they have developed. Just as the deliberations of the ILC had to continue under successive rapporteurs, one after the other, in like vein, it will be up to all of us in this room, each one of you, our students and our students, to see to the implementation of these principles on protection of the environment in relation to armed conflicts. To inspire us to do so, each laureate joins us today with a lifetime of service, accomplishment, and expertise dedicated to the rule of law. We have some photos to share with you of these two wonderful women. First, Ambassador Marja Jacobsson has recently concluded her service as the principal legal advisor on international law at the Swedish Ministry of Foreign Affairs. And parenthetically, I would say she was always an early pioneer in advocating international environmental law, for which I am also doubly grateful. She was a member of the UN International Law Commission from 2007 to 2016 and was appointed special rapporteur for the topic, seemed futuristic at that time, protection of the environment in relation to armed conflicts. In 2013, Marja Jacobsson had served at the legal department of the Ministry of Foreign Affairs in Sweden since 1982. Second, and we also have some photos to share, Ambassador Marja Lehto is the Ambassador for International Legal Affairs and a senior expert at the Ministry of Foreign Affairs of Finland, and I'm happy to say also an adjunct professor of international law at the University of Helsinki. She has been a member of the International Law Commission and was the special rapporteur also for the topic, protection of the environment in relation to armed conflicts. She chaired the Committee of Experts on Terrorism at the Council of Europe from 2006 to 2007, and chaired working groups on sanctions and terrorism for the Council of the European Union. While at the Finnish mission to the UN, she also chaired for a time the Special Committee on the Charter of the UN and strengthening the role of the organization, 1999. This time, may I invite Lilian Haub to come forward and also invite the president of Pace University and the dean of Haub Law School to come forward with the conferring of the Elisabeth Haub Award.
I'm honored to be here with all of you today to present the Elisabeth Haub Award of Environmental Law and Diplomacy to two remarkable women who have made a notable impact in our collective efforts to protect our world's environment. The Elisabeth Haub Award for Environmental Law and Diplomacy means a great deal to our family. This award recognizes the innovation, skill, and accomplishments of those who work to sustain and strengthen the world environmental order. We can think of no better tribute to the life and legacy of Elisabeth Haub, who worked tirelessly to promote an appreciation of nature and the sound stewardship and sustainable development of natural resources. Though this award for more than 20 years, through this award for more than 25 years, we have recognized the diplomats, policymakers, lawyers, and activists who have sought to protect our environment through the rule of law, the cooperation of world governments, and the group efforts of advocates across the globe. This mission has never been more important as it is today. With the catastrophic warfare that we have witnessed in recent days in the Middle East and over the past year in the Ukraine, the work of our laureates to protect the environment in times of armed conflict is of the utmost importance. And so it is my pleasure to officially welcome Ambassadors Marja Lehto and Marie Jacobsson as our 2023 laureates. On behalf of the Haub family, please accept my congratulations on this honor, which recognizes your many contributions to the global conversation on environmental protection. Congratulations.
I invite the Haub laureates to join the head table, and Dr. Nilofer Aral, the chair of the International Law Commission, also to join them. And we will have a chance to explore these wonderful principles that we celebrate today. Before we have an opportunity to learn about the principles and the views of those who worked so hard to draft them, we have greetings from one of the, I would say, world's great scholars and activists on environmental law, Carl Brook from the Environmental Law Institute. He has taped, he can't be with us today, but he has taped greetings, which will now be played.
Maria Marja, congratulations on this well-earned honor. I so wish I could be there to honor you and your efforts in person. As it is, I am in Kiev, Ukraine, advancing implementation of the principles. I'd like to take a few moments to reflect on your accomplishments. The principles are a landmark development in international law in 4 important ways. First, they expanded the sources of international law beyond international humanitarian law to include international environmental law, international criminal law, international human rights law, the law of occupation, and other sources. This was an important revolution in international law. 25 years ago, I remember there was a vigorous debate about whether international environmental law continued to apply during armed conflict, or whether IHL was lex specialis that excluded ongoing application and relevance of international environmental law. Drawing upon the ILC's previous work, you integrated these disparate threads into a cohesive body of international law, protecting the environment in relation to armed conflict. That leads me to my second point, in relation to armed conflict. That phrase extended the timeline beyond the usual exclusive focus on protection during armed conflict. This was important for many reasons. The environment plays a crucial role before, during, and after conflict. Moreover, there are many complex situations where it's not necessarily clear whether conflict is ongoing, ended, or in a pause. Third, the integration of international environmental law and other bodies of law enabled the principles to address non-international armed conflicts. This helps to remedy a long-standing gap in international humanitarian law when it comes to the environment. And finally, the principles address both damage to the environment and the wrongful exploitation of natural resources. By bringing in pillage and other aspects of natural resources, the principles have updated for our times the framing of protection of the environment in relation to armed conflict. Before I sign off, I would like to say a few words about how you went about your task. You were consultative. By engaging a wide range of experts in the process, you built buy-in that helped to ensure their success, relevance, and ongoing use. You were also careful. People asked you to incorporate a lot into the principles. Your judgment about what was lex lata and what was lex ferenda helped to ensure the legitimacy of your work. And you were committed. You had your regular jobs and no staff for this, yet you have, through an incredible amount of effort, led the creation of a set of principles that will guide us for generations. You and your work are inspirational, and we owe you a huge debt of gratitude. Thank you. And again, congratulations.
Well, Carl has set the stage for posing some questions. He's identified 4 areas of significance of these new principles. And I invite each of you to put on your thinking caps, because after we have some questions that have been prepared in advance, we want your questions and your thoughts. Gestate, think a little bit, get going, and I give you that warning. It really took nearly a decade to get to this moment, and when you begin a decade ago, you don't know whether you're going to get to this moment. It's a big challenge. So here we are with 27 principles. What were the notable challenges that each of you found necessary to cope with as you nudged these along and built them from the existing framework of law that you had to deal with? And how has your experience shaped your personal views of the role of the ILC in this? The ILC's importance has been larger or less large in different decades. I think it looms very large right now. But what are your thoughts of this? Marie, shall we start with you?
Yes, thank you, Professor Robinson. We agreed, Marja and I, that I should start because I was the first rapporteur. So the challenges really that I faced were of 2 kinds. One was structural, how to cut the cake, in essence. The other one was related to what topics should be included in the work. But before I comment on that, I'd like to say that the initiative in the ILC actually came from a report made under the United Nations Environmental Program, the Environmental Law Institute, where it's called Brooks Institute, and the ICRC that met in Nairobi and produced a report in 2009, where they recommended that the ILC should look into the areas of human rights law, international humanitarian law, and environmental law to see if the environment could have more protection during an armed conflict. Now, this is how it ended up in my knee when I was a member of the ILC. And I thought, to be very honest, I thought this wouldn't fly at all, because I had experiences from my work at the Ministry for Foreign Affairs during the Iraq-Kuwait war and the discussions in the UN when we had resolutions, and it was really, really hard, and it sort of boiled down to very little, but yeah, the interest faded away. But I decided that, okay, there is a request from another body that the ILC should look at it, and we should remember that the ILC is a collective body. So even if we are honored with this award, Marja and I, we shouldn't forget our colleagues in the ILC, because without them, it wouldn't have been possible. I just want to say this to make this clear. So the structure in this 2009 report was that they looked at the environmental law, international humanitarian law, human rights law, separate areas. And I realized quite early that that wouldn't fly in the ILC, not the way the ILC works. And we could have gotten stuck with that topic for 2 decades, basically, because it will never end. So the question was really how to cut the cake. And that's when I tested the idea on my colleagues in the ILC of whether it would be possible to look from a different perspective, from a temporal perspective. What are the rules in before an armed conflict, during an armed conflict, and post an armed conflict, after an armed conflict? Also encouraged by the work of some of the topics in the ILC, including effects of armed conflicts on treaties, where the ILC made very clear that environmental law provisions and human rights provision does not stop just because it is a war. I mean, treaties continue to apply. That's the message. So, having had recognition of this approach, of the temporal approach, what were the challenges? Well, there were quite a few, I must say. First, it was the issue of how to deal with all the provisions related to the laws of armed conflict, because everybody knows that the revision of armed conflict provisions requires something different than the ILC doing its work on it. So in essence, the law of armed conflict, I had to promise I'm not going to touch it. I'm not going to touch it really. The second issue was nuclear weapons, and I've had to promise several colleagues and states that no, I'm not going to touch weapons at all. I'm not going to mention nuclear weapons. And then the third was, of course, the non-international armed conflict. Would that be included? Would that be covered? We had also the issue of reprisals. That was a very, very tricky one to get into the first draft principles. And of course, the definition of environment. And I'm sure that Marja will talk about that a little bit. But also things that I had to leave out was shared natural resources, occupation. The Martens clause couldn't even touch it because we didn't have the time either. But there were a number of substantive matters that I had to leave out just to save what we could have in the topic. But now, as you see, these are in the principle, thanks to Marja's work. And I'll leave the second question.
Yeah, good. Marja?
Thank you. I think there's a general challenge that both of us encountered, and that's a challenge that is related to the wide discrepancy between the need for environmental protection in war-torn areas on the one hand, and limitations on how this need has been addressed in international law on the other. You can also say that this was a conflict between expectations and what was possible in practice. Protection of the environment in armed conflicts had been a marginal issue in the context of the law of armed conflict, and it had been largely ignored in international environmental law. You had the Rio Declaration, of course, but there had not been much in the way of follow-up to the relevant principles in the Rio Declaration. When I took over the task of being special rapporteur in 2017, and I think this is important to mention, I was able to benefit from the considerable amount of work that had already been done. For instance, the basic frame of the topic, including the temporal scope extending to the entire conflict life cycle, had been already endorsed by the Commission and by states in the General Assembly. At the same time, the substantive priorities that remained, the work that remained to be done, those were quite complex issues and posed their own challenges. As Maria already mentioned, they included protection of the environment in situations of occupation, issues of responsibility and liability, overall application of the principles to non-international armed conflicts, and complementarity with other relevant branches of international law. Then I should say that there was a further challenge related to the general understanding that the topic should be brought to conclusion within the same quinquennium. What then happened in practice was that the 5-year term was extended to 6 years due to pandemic, COVID-19. This came actually some more time for reflection, I would say, both to the special rapporteur and the Commission as a whole, and to the states. And in the end, it was beneficial to the topic. Obviously, you mentioned, Nick, the battles within the Commission. Obviously, it was always a challenge to convince the other members of the Commission of what was proposed. But that is part of the collegial process. You have to have better arguments than those who object to your proposals. And maybe I will also come to the second question after you.
Perhaps before the second question, Nilüfer, as the chair, observing and shepherding some of this along, how has this affected your view of the ILC to have this singular success today?
Well, thank you very much, Nick. And may I say what a tremendous honor it is for me to be part of this very important celebration of two outstanding women and dear colleagues and friends, and for their work, which really is truly remarkable. And I've said this to them, and I say it with all sincerity. In my view, I think this is one of the most important outcomes from the Commission, the work that they have done. And yes, it is the work of the Commission as well, but I'm going to actually touch upon something that Marja was saying. Without strong leadership in the Commission, and that is what Marie and Marja brought, and I know I'm a witness, because the Commission can be a very rough neighborhood. We have some very, very rigorous debates, and you really have to be in complete control and have a deep knowledge and commitment to your topic, which both of them had, I know. You have to be quite formidable to end up with the high quality product that we do have, in my view. So I didn't shepherd any of this, really, but I hope that I did give some support to it. But I can say, as someone who's been in the Commission now for a number of years, it is not an easy feat at all. So this award is well deserved.
Looking at it from the outside, at a time in which some people think it's hard to get disparate interests to agree on anything, it really is quite extraordinary that you've both succeeded in pulling together a consensus out of the diverse juridical views that are represented on the commission. Do you have personal thoughts about how that should shape the commission's work in the future?
Yes, I'm happy to come back to your question about the mandate of the Commission. Actually, I think that the Commission's mandate of progressive development and codification of international law is quite good. It's restrictive, but I believe it's consistent with the need for close cooperation, close consultation, and interaction with states, which is also required of the Commission. It means that the Commission cannot have the same liberty as academic scholars. It cannot be too innovative, and it certainly cannot be out of touch with the existing state practice. But I think this is something that ensures meaningful dialogue with states, and it's important. And I'm also quite optimistic regarding the future prospects of the Commission.
Yes, I agree. I have a very positive view on the prospects of the Commission. I mean, those who are used to argue that the golden age of the Commission is over because everything is already treaty-based, they are posing the wrong question, and they have the wrong assumption, because what we have seen in the last quinquennium of the Commission, we have seen how the Commission has opened up to cooperate more closely with expert bodies, with individual, and even with NGOs, which was, when I started in 2007, was not really that easy. But it turns out in a topic like the one that Marja and I have worked with, we have been highly dependent on close cooperation with also the ICRC and the knowledge of newly established NGOs and organizations like the Environmental Law Institute or the Conflict Environment Observatory Laboratory, and also of individual colleagues who we have met. And we have some here in the audience today that have helped us to develop thoughts and ideas, and many colleagues with an enormous amount of practical experience. So, and I think this is a reflection of the need of international law, and also that the Commission in its working methods has adapted to. And we see that also now during your quinquennium, and Nilofer, with all this new, I mean, your collective approach to sea level rise and so on, wouldn't have been possible when I started. So this shows a flexibility and an adaptation to the need of the international. Because this is not anything that the Commission have an idea of, let's do this and then go ahead and do it like a research project. It is in response of need.
And one of the innovations that you brought is in Principle 2, emphasizing that measures to prevent, mitigate, and remediate harm to the environment are in the entire cycle. You've added the S to conflicts, and you've taken the before, during, and after. Now, you indicated that reflected a willingness of states to allow that temporal debate to go forward and find principles that could help shape behavior. How do you see that as a development in your the text, and how did that get negotiated?
So I think that we should recall that we should recall that the environment is not an insulated silo. I mean, environment doesn't stop at a certain time. The environment is there all the time. It would have been impossible to just focus on one temporal area. And I also think that we mustn't forget that the focus of the aim of the principles is to enhance the protection of the environment in relation to armed conflict. It's an emphasis that there is already a body of law there, but how can we use that body of law to enhance the protection that exists, and how can we develop that? And I think that the general awareness among states and the international community has increased enormously of the consequences. You mentioned Ukraine, you mentioned Gaza, and this wouldn't have been possible if we hadn't had the engagement from everything. The media pictures are there. You cannot hide from what is happening any longer. You cannot simply say this is okay because it is war and we have nothing to do with it. You can look at what Ukraine has done and is doing now in the midst of the conflict. That is the first time ever that we have this kind of work by a state that's engaged.
Thank you. I would like to add is that the temporal scope extending from the time before to during armed conflict and after armed conflict, and includes situations of occupation. It's a defining feature of the topic. And I think it reflects first the experience of modern conflicts, which often don't have a clear, they are often non-international in nature, maybe with external involvement, don't have a clear end thoroughly. The other aspect, and you mentioned this, Mari, is that there was a recognition that protection of the environment has to be continuous from the time before the conflict, throughout the conflict time, in post-conflict situations. There are also quite important practical aspects to the temporal scope when you think of the topic as a whole. First, because we have this broad temporal scope, it means that the topic could not only focus on the law of armed conflict, but it had to take into account other areas of international law. Second, it meant that the topic does not only focus on the obligations of the warring parties, but has also sought to clarify what obligations other non-belligerent states may have, and what they could and should do to enhance environmental protection in relation to armed conflicts. And third, the temporal scope has also directed the Commission to identify environmental problems that are cross-cutting through the different phases of the conflict cycle. And two notable examples of such cross-cutting issues are the illegal and unsustainable exploitation of natural resources, and secondly, issues of responsibility and remediation. And both these issue areas are addressed in several principles.
The teaching about these principles, now that they exist, is going to be terribly important. We have many law students here and many early career lawyers here, and also on the internet online. And what would you say to them about what they should do with these principles now that they're in print, shall we say? Do we have some obligations? As a footnote, many of my students at PACE helped draft and prepare the UNEP training manual on international environmental law, which is online still. And we prepared a chapter on armed conflict and the environment, and it was not allowed to be published. Here we are 20 years later, and the things that we were going to publish have been superseded by the principles we celebrate today. So it is a marathon to carry on this race, but what should you advise all of us to do in universities now that you've accomplished your text?
Thank you. Certainly, universities, professors could encourage research on issues related to the protection of the environment in relation to armed conflicts. And it seems to me that this is already happening, whether or not triggered by the ILC work. There's much more legal research than before on conflicts and the environment, and different aspects of this broad topic, including, for instance, rights of animals in armed conflict. And I think it's telling that when the International Review of the Red Cross launched a call for papers last year in view of the upcoming special issue on protection of the environment and armed conflicts. It received more than 140 abstracts from all over the world. So if this has been a marginal issue, maybe at the time when the work was began in the Commission, it has clearly become more mainstream.
Yes, and I think that is very correct to say. It is mainstream today, and the amount of work that is done is impressive. But it is also important that the work that is done at university reaches the politicians and the decision makers. So it doesn't stay with the university. It should go disseminate it in many ways. You can still keep the academic integrity, I think. I think that if there is any sort of advice, which is not really academic, but it is, don't be too romantic about the implementation of this. Because if you're too romantic, you're going to be disappointed. And if you're disappointed, there is a risk that you become cynical and put the topic aside. Keep up your engagement and be realistic, but continue to disseminate and research.
One of the important aspects of this set of principles is to draw on perhaps what ecology is teaching us about the biosphere. And you've used the word environment rather than natural environment, which many humanitarian law instruments refer to. Does this choice of word mean something?
Maybe I can shed some light on the use of terms in the context of the principles. The term environment has been used right from the beginning in most of the principles, but the term natural environment was used until the second reading in those provisions that draw from Additional Protocol 1, because this is the term used in Additional Protocol 1. In 2019, the Commission indicated that it would reconsider the use of terms at the time of second reading. And then several states and international organizations, because we invited not only states, but also international organizations and other stakeholders to send in written comments. And the great majority of them expressed their view and preferred the term environment. It was pointed, for instance, pointed out that the term environment reflected better developments in the international law in this area since the adoption of the additional protocols in 1977. It was said that it would be consistent with the broad approach that the Commission had decided to take on the topic. References were also made to changes in the scientific understanding of the environment. And it was pointed out that environmental issues were not limited to the natural environment, but also included human rights, sustainability, and cultural heritage. The concept of natural environment was seen as outdated. These are only few comments that were made. And the Commission therefore, and this had been my proposal already in 2019, decided to use the term environment throughout the principles. And as you asked what this means, whether it does have consequences, I should add that the relevant commentary includes a safeguard clause, according to which the fact that the principles refer consistently to the environment in line with the established terminology of international environmental law, the commentary says, this should not be understood as altering the scope of the law of armed conflict or the notion of natural environment as it is used in that law, especially Additional Protocol 1. And let me add that the difference is not necessarily that wide. The ICRC in its updated guidelines on the protection of the natural environment in armed conflict, points out that the concept of natural environment should be understood in the widest sense possible.
For me, when we had a discussion when the work started, this was a very, very tricky question, and the views were not as mature as the ones that Marja just described. There was a very, very strong resistance in the Sixth Committee and also among some members of the Commission to use environment without any qualification due to the laws of armed conflict regulations. So this is why, as a compromise, and this was also tough to include, was in the first suggestions to draft from the drafting committee, we, the commission that I was a member of, decided to use natural environment, the laws of armed conflict term in the section that dealt with during armed conflict. But it was this is really a good example that the international community, states, and also the members of the commission has come to a different, as a time change, they have come to a different understanding that we cannot have this distinction. We need a different view on it. And I can say that this was an issue that could have hindered the entire project when I was a special officer. So sensitive. So I just had to suggest to put it aside.
I may add, I think this was a very important point and shows that there has been a learning process during the 10 years that the principles have been in the making, a learning process within the Commission and within the broader international community.
That broader international community also was very pleased when you added Principle 18 on the protection of protected areas, already designated parks and national parks and so on. And part of the popular enthusiasm of states for protecting the environment, we see in the Kunming-Montreal framework of the Convention on Biological Diversity, which calls for states protecting 30% of the biosphere of the planet by 2030. What do you think the implications are for Principle 18 and the duty of states with respect to this prospect that maybe a third of the planet will be off limits?
Principle 18 is, of course, closely related to Principle 4, which concerns designation of protected zones. The two principles are the latest addition to, I would say, a series of proposals concerning area-based environmental protection in armed conflict. The earlier ones include a proposal that was discussed already in the negotiations on the two additional protocols to the Geneva Conventions in the 70s, the IUCN Draft Convention, the San Remo Manual on Armed Conflict at Sea, and there are more recent examples, a proposal contained in the ICRC guidelines I mentioned earlier, which call for designating areas of particular importance or fragility as demilitarized zones. And one proposal was quite recently made by the UN Secretary General. The proposal that was made in the negotiations of the additional protocols in 1970s, in the 70s, did not make its way to additional protocol 1. And there were specific problems that were highlighted, reasons for leaving it out. And these problems were related first to the difficulty of identifying the selection criteria. Secondly, the perceived lack of objectivity in the designation and the risk of abuse. And third, the question how it could be secured that the designation of the selected area is respected. And I think it can be said that the problem, two of these three problems, those regarding the criteria and the problem of objectivity of designation have now largely been overcome. Exactly because there are widely ratified environmental agreements that provide for area-based protection. What is left is the question of respect in times of armed conflict. And Principle 18 envisages exactly this situation. Principle 18 provides that the zone that is designated by agreement shall be protected against any attack, except insofar as it contains a military objective. Whether such a designated area will remain protected in armed conflict will also depend on the agreement concerning its establishment. Ideally, there should be measures of active protection. There should be provisions concerning measures that reduce the likelihood that the zone would be affected by military operations, and so on and so forth. So it's not as much work remains to be done to implement this principle, but it gives a certain basis for doing so.
No, I think that the principles as they now look, as they now in the final form, it has really developed the thoughts that were in early suggestions, but which were not at the time not ripe to be formulated in the strict way as they are now. Just to have the reference to a protected area was a difficult suggestion and a difficult issue to handle, because again we have a question of who would do this. Would it be? I mean, it was like establishing a zone in an international water area. How do you do that? How do you respect it? We know that the law of armed conflicts are very clear on what can be done, but and it doesn't really protect. But now we have a clear signal that the parties that are engaged in an armed conflict and will have to take this into account, but also that states are encouraged to consider, are there any areas to be protected in advance of an armed conflict, or in case there is an armed conflict. So that is really a development.
So one of the great successes, in my opinion, of the principles was including in Principle 12 a Martin's Clause for the environment. And for those who don't remember it, the environment remains under the protection and authority of the principles of international law derived from custom, principles of humanity, and the dictates of the public conscience. The public conscience, as everyone has said on this panel, is clearly evolving. And Nilüfer, as the chair, you've introduced some of these new topics of this Anthropocene that we're in to the deliberations on sea level rise and so on. Do you have thoughts about where the Martin's Clause should go?
Well, first of all, I should say that it was also an important success because as both Marja and Marie have indicated, not all members of the Commission necessarily embrace these concepts being extended into the environment. And in this case, there was a debate, and it did happen. And indeed, it's an important part of the principles. Where they could apply, hopefully there won't be armed conflict and sea level rise. Sea level rise alone already is challenging. But certainly it's a great protective device, I think. So here we know that even where there's not specific codification, that there will be protection of the environment. And I think this is a very important development. I just wanted to add to that, it is I think just looking at that 10-year trajectory and seeing how it evolved, and that it's true, we would not have had these principles at the beginning So sometimes certain things have to, shall we say, be brewed over time, and also so that people can understand. And I think for states as well, not just members of the Commission, for states. So clearly that, including the Martin's Clause for the environment, the principles, the time had come for them. So I don't know if I answered your question exactly,
Your
but.
Wonderful answer, but now you've had time to think about your questions. Do any of you have questions you want to pose? Certainly the conscience of mankind and the Martin's Clause should be triggering some thoughts. What do you want to see these principles develop into, or do you have any questions? Yes, please.
Ratification of Lex Lata, and they should be implemented right away. Another third, perhaps, could be principles that are Lex Ferenda, but are on the right track, so to say. So we could expect them to be implemented at once or very soon. And the third one, now we come to the Martens Clause, perhaps, may be principles of lege ferenda that could not be thought of being implemented tomorrow, but later on. And I wonder how Marie and Marja would grade the different principles in the that you have adopted with regard to the future prospects of a good implementation.
So I'll try to give my view on that. I think that one of the things that I learned when I was the special rapporteur was not to grade the importance of the principles, because the situation is not static. So what was not accepted as a recognition of a law, of a binding rule 10, 15 years ago may be recognized as a rule now. We have an enormous amount of case law. We have an enormous amount of resolutions adopted in the General Assembly, and also new development within the field of treaty law, biodiversity, for example. So it would be, I think I'd be reluctant to grade the principle, because it's like you don't freeze customary international law, for example. That develops. What was customary law 20 years back might have developed into, or what was not 20 years back might have developed into something now. So I think that there is a certain, perhaps a certain, little bit gloomy, perhaps, to say about the principles, but I would be reluctant to map them in different categories.
I fully agree with Mari's point. Many of the principles reflect existing customary rules. It might be more than 1/3, which have been interpreted in light of subsequent developments in international law. Then there are, of course, the principles that have to be seen as proposals for progressive development of international law. But as you said, what we now classify as progressive development might become firm law in a decade's time or even sooner. One example, a proposal concerning the protection of the lands and territories of indigenous peoples. It was seen as a recommendation when it was adopted in first reading and used the term should. But then the Commission agreed that it should be, in light of the legal developments, it should be written in a prescriptive form. And that was the final outcome. Let me add just one additional aspect. Given that the principles and commentaries have been prepared very much in consultation with states and international organizations, it can be hoped that these end users will find them useful and take steps to consult them in their practice.
Other questions? Simi?
Well, I'm delighted to hold the mic to have the opportunity to congratulate two women who are amongst those I admire most for the work that you've done, richly deserved. So taking the trend of this conversation one step further, do you have hopes or would you advise that the principles might be introduced into rules of engagement or military handbooks? Would they be even, are there ways that you could imagine them being applied in the current conflicts that we're looking at? Would you even like to see journalists just talk about them in an editorial in tomorrow in the newspaper?
Where are these rules going to go?
You mentioned current conflicts. If I may take an example of the ongoing armed conflict in Ukraine, I believe the principles are quite relevant. If we only focus on the provisions concerning situations of occupation, taking into account that Russia has been occupying the peninsula of Crimea for 8 years or more, and is now occupying large parts of eastern Ukraine. The principles identify a number of environmental occupations, a number of legal obligations that occupying power has towards the occupied population, the occupied state, and other states. And I believe these are quite relevant in the context of the war in Ukraine. And also taking into account recent jurisprudence by the International Court of Justice, which has clarified in an important way the responsibility of an aggressor state, the special responsibility of an occupying power, and also the compensability of environmental damage, including damage to the environment in and of itself, meaning pure environmental damage. All this is reflected in the both in the principles and in the commentaries. And I think it's most relevant when we think of where we go from this situation in Ukraine.
Thank you for the question. I think that about the rules of engagement, I would certainly hope so. And I think that there is a misunderstanding among many individuals that they are not already, principles like this are not involved in rules of engagement. I had the opportunity to work closely with several states when I worked on the applicability during armed conflict. And to my great surprise, I found that you already have quite a few rules of engagement and or instructions or guidelines and so on and so forth. Because if it is a decent party to an armed conflict, they know that they would benefit from themselves, us by themselves, if you have proper rules of engagement that take this into account. What I would say also about the role of the principles, I very much would like to stress the post-conflict phase now, which we forgot to talk about perhaps a little bit earlier. It's because we have today a recognition, if you look at Ukraine, for example, of the fact that what we're talking about are environmental crimes. Some might be war crimes, some might be just plain environmental crimes. There is a liability, there is an accountability, and you can see that also in the principles, and which include also the post-conflict phase and the rebuilding of a society that is war-torn, as Marja referred to in one of her initial comments. We also need to know that the international community has a responsibility, and so has international organizations, because this has transboundary effects. It's not only a question for the warring parties. And this is also when, for example, why we had such an engagement at an early stage from the Pacific Island states. They were affected from the effects of the Second World War in their area by activities that were not necessarily illegal at all, but it affects their territory and their environment now. And we cannot simply say, well, this was illegal, this was not illegal, so we can skip it. The international community has to step in. So this is also foreseen in the principles, and I think that is very important to remember.
We have time, thank you. We have time for one more question. We have a pressing question from everyone here. Yeah, please, go ahead.
Hello. Thank you so much for the panel discussion so far. I was just wondering.
Hold it close to your mouth.
Yes, is that better?
Yes.
I was just wondering, because you have discussed the temporal scope a lot. What struck me as well was the personal scope of the principles. So while they are predominantly addressed at states, they also cover other actors like non-state actors, international organizations, and if I remember correctly, even corporations. So could you share your thoughts on why those were included as well? Thank you.
Thank you. The principles generally do not make a distinction between international armed conflicts and non-international armed conflicts. Generally, I said, because there are some areas that only apply to international armed conflicts, for instance, the principles applicable in situations of occupation, because that concept is not so far legally recognized in non-international armed conflicts. But then there are many principles that have particular relevance for non-international armed conflicts. And we have also, this was something that was done in the context of the second reading. We extended the personal scope of some of the principles to cover other relevant actors, including non-state armed groups and de facto authorities, taking into account that there have been, it has been a common feature in many recent conflicts that non-state actors have exercised control over people and territories, sometimes for a very long time. You also mentioned corporations. There are two principles regarding due diligence of business enterprises and liability of business enterprises, but actually these principles are addressed to states. States are requested to take legislative and other measures to make sure that business enterprises, when they operate in conflict-affected areas, exercise due diligence and can be held liable if they cause environmental damage. So, but there are many other examples of principles that are addressed also to international organizations and other actors in addition to states.
Well, I want to thank very much our panel. I want to thank Nilüfer Aral for being with us as the chairperson of the commission. And we will invite, you want one more question?
Hi, yes, thank you
Okay.
for your presentation and for your contribution in such an important area of the law. I'm going to read a question from the chat.
Oh, from the chat, our internet.
Yes,
Yeah.
it's from Edith Brown Weiss. She's asking, what issues will artificial intelligence raise for the content of an implementation of the principles? Should we be concerned? Thank you.
So Edith Brown-Weiss, always looking into the future, has challenged us with one of the biggest questions of the present. Do you see a role for AI in these principles?
Maybe in the implementation of the principles, why not? We have seen how new technologies have really changed how environmental damage can be documented. There are many innovative ways to do it, from satellite imagery to crowdsourcing in a way, public participation. Why not? I am not an expert of artificial intelligence, but I would think that an ability to deal with information, great masses of information, would certainly be could certainly be useful in the implementation of the principles.
Well, I think generative AI needs to be programmed with algorithms that are going to advance these principles. How we get to the algorithm writers is going to be the next challenge. Nilüfer, you have a comment?
I just wanted to add something, just to inform that some months ago, the elders, in a statement of concern about AI, actually recommended that the ILC take up the issue of AI. So if that ever happens, perhaps we could include armed conflict in that.
Well, Edith Brown-Weiss has raised a very provocative way for us to end our formal discussion, but this will stimulate the informal discussion at the reception now. So I invite you all to engage our laureates, both congratulate them and to engage them in further questions next door in the reception, which we'll now hold. I apologize to those online that we cannot have you at our virtual reception, but thank you for being with us. And if I can ask for one more round of applause for these two exceptional laureates.